are in listen-only mode.
Good afternoon. I appreciate you joining us today to talk a little bit about marriage equality and what, more importantly, perhaps, or just as importantly, what comes next. So we're going to talk a little bit about how we got here, and then we're going to talk, hopefully, a lot about where we go and some of the things we can anticipate from an employment and workplace standpoint. I want to let you know that the PowerPoint presentation will be available on our website after the presentation, either later today or no later than tomorrow, fishelhas.com. Also, please feel free. In fact, I would encourage you. I know it's kind of odd to do it over the computer, but ask questions as we go along. I think it makes it more interesting for everyone, and chances are, if you have the question, others do as well. Um, so the first question really is, how did we get here? And I'm going to spend a few minutes talking about this because not only does it lead to the Obergefell decision, but I think it guides us a little bit, at least in my mind it does, about some of the things that we can expect with regard to transgender and sexual orientation issues in the workplace, based on what the court has said in the Windsor and Obergefell case. So first, just real quick, we go back to 1972 when two males sued the state of Wisconsin. No, I'm sorry. It is the state of Minnesota. I'm not sure why it says Wisconsin in there. I guess that's an error on my part. But sued the state of Minnesota for refusing to issue them a marriage license. The federal court of appeals that heard that case held that there was no cause of action, and the United States Supreme Court, which doesn't have to accept appeals, they have a discretion for the most part, just issued a one-sentence decision that said the appeal is dismissed for want of a substantial federal question. Obviously, we've come a long way in the 40-some years since Baker versus Nelson, and that takes us up to the Windsor decision, which was in 2013, and that dealt with the Defense of Marriage Act, or DOMA, which was a federal law defining a marriage as one man and one woman. As you folks, I'm sure, recall, the United States Supreme Court held that statute, as it applied to as it applied to marriages in states that recognize same-sex marriage, was unconstitutional. So Windsor didn't say that marriage between had to be between a man and a woman, nor did it say that states were prohibited from defining it as such. It just said on the federal level, the federal government, for all purposes, is going to and has to recognize marriages that individual states recognize. Justice Kennedy wrote that opinion, which is interesting because Justice Kennedy also wrote the Obergefell decision. I think a lot of people, even before that decision, the Obergefell decision came out, were anticipating he would be writing the decision, not just because he's a swing vote, but because he has a history on some of these issues. As I said, gay marriage still remained illegal in many states, and the federal government looked at this place of celebration. One of the things that's important to keep in mind from the Windsor decision that we'll talk about again later is that the court found that the purpose of the law the court determined that the purpose of the law was to do harm and disparage a group of people, gays, and lesbians, which led the court to use a strict scrutiny standard. A strict scrutiny standard is applied by courts in certain cases involving challenges to government regulations that impinge upon or have a disparate impact on certain protected classes or groups of people or certain rights. Strict scrutiny is the highest level that the court will use. Sometimes courts will use a rational basis test. In other words, they will say, okay, does the government have a rational basis for this rule or regulation or statute. In a strict scrutiny cases, the government has a much higher burden to establish that the rule, or in this case statute, DOMA statute, served a compelling government interest. And that's going to be important, I think, because that standard could very well be applied down the road when we're talking about discrimination cases involving sexual orientation. And we will talk about that. So then we move up to between 2013, actually at the time the Windsor decision was issued in June of 2013, there were 13 states that recognized same-sex marriage. By the time Obergefell was issued, there were well into the 30 some odd states. Many of those states started recognizing same-sex marriage because a federal court of appeals overturned a state's ban. Actually, if I recall correctly, every federal court of appeals that heard that decision, with one exception, overturned state bans. And the exception was the Sixth Circuit Court of Appeals, which is the court of appeals that governs Ohio. The Sixth Circuit Court of Appeals heard Obergefell, along with 3 other challenges from Michigan, Kentucky, and Tennessee. Those are the 4 states that make up the Sixth Circuit jurisdiction. And so in November of 2014, the Sixth Circuit Court of Appeals, in a 2-1 decision, upheld these same-sex marriage bans in those 4 states, basically citing back to the Baker case and everything since 1972 where there were challenges, they were all rejected. The Sixth Circuit's decision also stated that this is really an issue for the legislature, and it's not something where courts should jump in. Obviously, the U.S. Supreme Court disagreed, and in June of this year issued a 5-4 decision striking down all same-sex marriage bans. In this case, for some reason, the court did not use a strict scrutiny standard. I mean, they didn't really even cite to that and said they didn't conclude that that there was no compelling government interest. They didn't get into that argument. They really looked at it from an equal protection and substantive due process point of view, much like the court's decision in the late 1960s in Loving versus Virginia. In that case, in the Loving case, that was where the court overturned Virginia's ban on interracial marriage. The major theoretical driver for the opinion is the U.S. Supreme Court's decision in a case called Zablocki. It's Zablocki v. Red Hale. It's 434 U.S. 374 if you want to take a look. It's not in the PowerPoint. But in that Zablocki case, the U.S. Supreme Court recognized that there is a fundamental right to marry. So marriage is a fundamental right, according to the U.S. Supreme Court, as far back as 1978, but now reaffirmed in 2015. And I think that's also important as well going forward in terms of discrimination cases. And we'll talk about that in more detail. But let me just tell you real quickly why I think that is important. Right now in Ohio, there, of course, is no protection. There's no statutory protection for discrimination based on sexual orientation. There are some cities and counties that have some local ordinances, but no statewide protection. Many states have it. Some states still don't. So in Ohio, for example, a person can get married over the weekend to their same-sex partner and be fired on Monday because there's no law prohibiting discrimination based on sexual orientation. Well, my question is, and this is especially true for public employers, but even perhaps private employers as well, will a court reviewing that case, that presuming somebody gets terminated and then they turn around and sue based on sexual orientation, will the court allow an employer to fire somebody and usually it's not explicit, but oftentimes it's implicit, or that somebody would allege that the real reasons given is subterfuge for the termination, when there's a fundamental right involved. So somebody exercises a fundamental right, marriage, and is terminated because of it. I think courts might have a difficult time with upholding that termination or not reversing that termination. And again, we'll talk more about that, but these are the reasons why I wanted to spend a couple minutes on the mostly recent history. Just one final point on the Obergefell decision. One of the dissenting judges, Justice Roberts, expressed concern that this could lead to polygamous marriage. The courts, in its majority opinion, went out of its way to say marriage between two people. At this point, I would be surprised if Obergefell is successfully used to argue that polygamous marriage should be lawful or recognized. I do want you to know that there's one case that's winding its way through the federal courts of appeals, coming out of Utah. What a surprise! That the case involved a criminal statute that prohibited or cohabitation as if the individuals were part of a polygamous family. And this statute at the district court level was ruled to be unenforceable. Again, that's a sort of an aside just to make you aware of the full playing field. So I want to talk about a few of the workplace issues relating to a few of the workplace issues that we're going to talk about here in the next 45 minutes or so. First of all, we're going to talk a little bit about transgender discrimination, and there's several issues that have already been going on well before the Obergefell decision. Sexual orientation discrimination, benefits for same-sex partners, and state and local protection. So, of course, as I just mentioned, and as you folks know, there's no statewide law in Ohio protecting individuals from discrimination based on sexual orientation. There's also no federal law that protects individuals from such discrimination. There is, however, and has been since 1964, Title VII of the Civil Rights Act. And what that says is, and you see it on your screen there, but employers cannot fail to refuse to hire or discharge any individual or otherwise discriminate with respect to terms and conditions of employment because of the individual's race, color, religion, sex, or national origin. And over time, these various definitions have been expanded or for protection. For example, there is no law that prohibits sexual harassment in the workplace. It's derived from Title VII. Well, as you'll see here, Title VII is also the vehicle that some have used and will be trying to use in order to establish prohibitions against discrimination based on transgender and sexual orientation issues or characteristics. So where we start out with in terms of transgender discrimination is a case not involving sexual orientation and not involving transgender discrimination. It's rather a more straight over the plate sex discrimination case, and it's Price Waterhouse versus Hopkins, a decision issued by the U.S. Supreme Court in 1989. And what Price Waterhouse stands for, well, what happened in Price Waterhouse is that the plaintiff, Ms. Hopkins, had been an employee of Price Waterhouse for many years, and she was up for partnership, and she was denied her partnership. And essentially, what the court determined, based on the facts, is that when she was denied the partnership, she was told that she should act, dress, and talk more femininely in order to receive it. The court the U.S. Supreme Court didn't have a very difficult time in concluding that her denial of that partnership was discrimination because of sex, because Ms. Hopkins did not meet the quote unquote norms that were expected of a person in that position in the mid to late 80s, whatever that is. And of course, that obviously changes over time as well. So Price Waterhouse is the jumping off point of for some of the transgender and perhaps down the road sexual orientation discrimination protections. One of the questions that we have to pay attention to and be asking ourselves is how far will the Price Waterhouse holding go in terms of sexual orientation cases, because if we have a certain expectation that men will do certain things, including only marry women, is that discrimination because of sex if we take actions because a gay man decides to marry another man? The court is not there, let me make that very clear, but that could be where we're headed. And one of the reasons I say that is because of this case on your screen now, the Smith versus the City of Salem, which was decided in 2004 by the Sixth Circuit Court of Appeals. And there are other cases, both in state court in Ohio and throughout the country, that reached a similar conclusion with regard to transgender discrimination. And we're going to spend the next few minutes talking specifically about transgender discrimination, because in some ways it's easier to talk about. It may be more difficult to address in the workplace, but it's easier to talk about because there's case law giving us an idea of what the expectations are. And to cut to the chase, Smith v. City of Salem and other cases like it have recognized that discrimination by an employer based on transgender status, that someone's biologically a male but wants to be a female or vice versa, it is protected by Title VII of the Civil Rights Act of 1964. There is no need to have additional laws in place to protect individuals from this type of discrimination. So what happened in the Smith case is that the plaintiff, known as Jimmy Smith, had begun to behave more and more femininely, including in the workplace. Jimmy Smith was a firefighter, which meant he was living together, so to speak, with other firefighters during their duty time. A little bit different than a 9-to-5 office job, although legally it doesn't matter. And the evidence showed that the employer, the City of Salem, had implemented a plan to force his resignation, including giving him a 24-hour suspension for a minor and what turned out to be pretextual policy violation, and implemented new requirements that he undergo a psychological examination. Now, one thing to keep in mind here is the Americans with Disabilities Act explicitly excludes transgender as a potential basis for a claimed disability under the ADA. So this is not an ADA case, although I would throw out this point, even though transgender status is not a disability under the ADA, when an employer sends somebody out for a psychological evaluation, is there a presumed disability claim? Again, that's kind of an aside because that's not the point of this case. Ultimately, what the court said is that the employer was taking adverse action against Smith because it felt that the employee, Smith, should have been acting in a different way since he was a biological male. And that is a violation of Title VII because of discrimination because of sex. So as a result, this theory applies to any negative employment decisions that are caused by the employee's gender nonconforming or transgender status. Um, and that leads to some other issues. One of the things, before we talk about some of these issues, one of the things I just want to make clear is, at least as I understand it, and I certainly don't try to know all the science or pretend to know the science or anything like that, but from a legal standpoint, a person is protected by Title VII based on their transgender status, irrespective of whether they've made any efforts to biologically change from a male to a female or vice versa. It is enough that the person who is a biological male says, "Hey, I am I am a biological, or I'm a biological male, but I want to be um, a, a female, or I feel like I should be a female, or I identify as a female." So that's enough for that person to say that. Um, so an issue that has come up several times has been the question of restrooms. Um, and actually, the same just weeks before the Sixth Circuit's Court of Appeals opinion in the Smith case, the court upheld a dismissal of a Title VII claim by a transgender employee who wanted to use the restroom corresponding to her gender identity, saying that that was not protected by Title VII. That decision was issued in 2004, and that is still the law of the land in the Sixth Circuit. However, issues are being more complicated based on realities in society. The Equal Employment Opportunity Commission, in a case, recently interpreted Title VII's prohibition against sex discrimination and found that it applied to an employer who denied their transgender employee access to the restroom corresponding with her gender identity. And that's this Lusardi case on your screen. And just so you know, the EEOC, of course, as you're aware, is charged with investigating discrimination claims or charges. The EEOC also can refer cases to the Department of Justice and participate in lawsuits, or actually sue an employer for a violation of Title VII and other laws under its jurisdiction. And the EEOC actually is a hearing body for Title VII violations of federal employers and federal employees. So that's how the Lusardi case got to this decision. It was a federal employer uh, that denied access to the bathroom. So you don't have to worry about, well, I shouldn't say you don't have to worry about, the EEOC decision in this case is not binding on anyone other than federal employers. So in this kind of situation, really all you need to be concerned with is that this is what the EEOC is going to push going forward in discrimination charges, and also looking for lawsuits to either participate in or to bring on their own. And essentially what they said is that, as I mentioned before, that the employer has to allow the employee to use a bathroom that is conforming to their gender identity, not necessarily to their biology. Now, it might be enough that you have a unisex restroom that works for everyone. That's, again, just like the ADA, I don't think anybody under this theory gets their chosen accommodation or chosen solution. It's what is reasonable under the circumstances. I just want to throw out something as an aside for what it's worth, just so you know, you're aware of it, because this issue could easily arise in a transgender bathroom situation. I know it seems like we're spending a lot of time on this, but it's coming, and there's going to be more and more of this. I was recently involved representing the city, or advising the city of Bexley here in Franklin County with they adopted a non-discrimination ordinance that on a local level prohibits discrimination based on sexual orientation. And not surprisingly, there was certainly some opposition to that eventual ordinance. and some of the opposition came from a group, and I'm not recalling their actual name, but they're a national organization that opposes these types of ordinances. And one of the things they brought up was the potential danger to women in allowing a man to use a women's restroom, to women and children, because of course, if you bring up children, that sounds even more nefarious. And they cited some supposed examples of newspaper articles when this occurred, where somebody was attacked because a man falsely claimed to be a woman and went into a restroom and attacked a woman. I'm not going to say it couldn't happen. I'm not going to say it hasn't happened. Their examples didn't really register or pan out with the facts of the situation. And after having done some research on this issue, the what we really find is that there are many more examples of a biological male dressed as a female, or not just dressed as a female, but identifying as a female, being attacked because they have to use a men's room. So again, it's not as simple as just saying this is going to happen. Oh, one of the participants has kindly texted me and told me it's the Alliance Defending Freedom. That is the name of the organization, if you come across them. One last thing about the restrooms is OSHA. The Federal Department of Labor, OSHA, has recently issued best practices guidelines. These are not rules or mandates regarding restroom access for transgender employees. And they have cited in support of their guidance, they have cited potential psychological harm to employees who are not able to use restrooms corresponding with their gender identity and potential negative health effects of not using the workplace restrooms at all. OSHA suggests employers allow access to gender identities corresponding restrooms based on the identity and not the biology of the person. Although, again, that is just a suggestion. I alluded to this before, but the OSHA guidance offers a best practice idea of consulting with any transgender employee on what they find to be an appropriate and safe option, and allowing employees, without requiring proof of legal or medical changes, to use whichever facility corresponds with their identity. So that suggestion makes a lot of sense, because first of all, talking through an issue could avoid a lot of potential problems, even though it's not an easy issue to talk through for a lot of people. And the other thing is, a reminder there, you really can't, from a legal standpoint, you can't require proof, because the biology doesn't matter from a legal standpoint. In other words, and I'm sorry if I'm repeating myself here, but I think it's important to make clear, it doesn't matter. A transgender person is going to be subject to Title VII protections whether or not they've gone through the medical changes that are needed to actually physically make somebody a woman who used to be a man, or vice versa. So don't ask for proof. Yes, in the off chance that you have somebody who decides to come in today and say, I think I'm a woman, because they really want to hang out in the women's restroom or something like that, and see all the couches that women get in their restroom or something. They are much fancier, I've heard. Yeah, okay, you can put your foot down in that kind of situation, but that's by far going to be the exception. So that's just something else to keep in mind as you're winding your way through some of these issues. I'm going to move on and talk about sexual orientation discrimination now. I have a feeling that in about 3 years, this presentation could not be done in an hour, because there's going to be a lot more case law and a lot more guidance on on some of these things. And as you'll see on some things I'm going to talk about here in a minute and have already talked about, I think things are going to happen fast too. Now, of course, in the legal world, fast is 2, 3, 4 years, not tomorrow or next week or next month. With regard to sexual orientation discrimination, of course, as I said, Ohio doesn't have a law governing this. There's no federal law governing this, but not surprisingly, many people have argued, and it appears the EEOC is on its way to adopting a position that the current prohibition against sex discrimination under Title VII of the Civil Rights Act of 1964 it protects against discrimination based on sexual orientation. So you have on your screen here a reference to another EEOC federal employee, federal employer decision. Again, it doesn't apply to any private or public employees or employers other than the feds, but it shows us what the EEOC is likely to do moving forward. So in this case, the EEOC essentially provided guidelines about how Title VII could apply in sexual orientation discrimination cases. And what the EEOC did is it noted a history of the expanding interpretation of Title VII discrimination to prohibit adverse actions based on an employee's failure to conform to gender stereotypes. It also has, as I said before, expanded in terms of sexual, racial, religious type harassment in the workplace. And what the EEOC said is this more expansive reading of Title VII prohibitions has also included employment decisions in which an employer has relied upon sex-based considerations. So if an employer is taking gender into account when it's deciding to fire someone or not hire someone or pay someone less or fill in the blank, then in that kind of situation, it seems to me, and it seems to the EEOC, that that would fall within Title VII. But you need to be clear. We need to be clear. There is no sexual orientation reference in Title VII, and that has been significant to courts up to this point. So what the commission said is that it offered 3 different theories under which Title VII could support a claim for sexual orientation discrimination. First of all, it said if the employer's treatment would not have occurred but for the individual's sex. For example, if I have a picture of my wife on my desk, nobody says anything. Maybe nice picture, but no big deal. If I am married to a man and I have a picture of him on my desk, and that leads to some kind of discriminatory conduct, is that discrimination because of my sex? I mean, I think there's a good argument that it is. And I want to stop here before I get to the second and third points and make something else clear here. As these theories develop, not only are employers going to have to be prepared to explain potentially why they didn't discriminate based on sexual orientation, but employers are also going to have to take reasonable actions to make sure its employees don't discriminate or harass somebody based on their sexual orientation. And that's going to be a real challenge, especially as it relates to the argument where my religious rights bump up against somebody else's right to be who they are and be gay, lesbian, transgender, or bisexual. The focus of our presentation isn't on the religious part of things, but I will talk about that here in a few minutes. Going back to the EEOC's decision, the second theory applies if the treatment was based on the sex of the person or persons the individual associates with. For example, if the adverse decision results in from the gender of the employer's partner or, the employee's partner or spouse. So you're taking action because I'm married to somebody or date somebody who's of the same sex? Are you now discriminating against me because of my sex under Title VII? The EEOC seems to imply that you would be. The employer would be. And the third theory is if the action was premised on the fundamental sex stereotype, norm, or expectations that individuals should be attracted only to those of the opposite sex. This kind of goes back to the Price Waterhouse versus Hopkins case, that there is a certain norm that's expected of men and a certain norm expected of females. I fall way short on that because I can't. I'm one of the least handy people I know, and I know there's an expectation there, but I fall way short. But when we're dealing with these issues, I mean, again, we're not going to go from this EEOC decision to this being the law of the land overnight, but I certainly understand where the EEOC is coming from on these issues. And up to this point, it's been, other than with transgender cases, it's been rather easy for employers to get cases dismissed that are based on sexual orientation discrimination, based on just the law doesn't recognize that. And I think that's going to change. I think that is changing. Now, I do want you to know, though, in the Sixth Circuit Court of Appeals has already been presented with this argument in 2006 in this Vickers case. And the Sixth Circuit Court of Appeals in 2006, the person said that he was perceived as being homosexual, which was the basis for his adverse employment action and the Title VII claim. And the Court of Appeals said that because Congress declined to incorporate sexual orientation as part of the list of protected attributes under Title VII, it would be impermissible for a court to, in reality, amend the statute to read gender stereotyping as a theory of sex discrimination, which is kind of interesting because there was gender stereotyping in the Price Waterhouse case, and even gender stereotyping in the transgender cases, which the Sixth Circuit recognized, falls under Title VII. So that the Vickers case is the law of the land in the Sixth Circuit right now. One other thing, really for public employers more than private employers to be aware of, is another rationale for potential discrimination or a lawsuit based on sexual orientation would be, you fired me because of my association with a person who is gay, lesbian, etc. Whether that association is because I'm a member of the Human Rights Campaign or another advocacy group on behalf of LBGT. I always have to stop to see if I did that correctly. Or if it is just because of my association, my marriage to somebody. So the First Amendment of the U.S. Constitution protects freedom of association. That doesn't apply to private employers, but it applies to public employers. So I think from that perspective, that would be another avenue for courts to say that that there was a violation of the law if someone is terminated for those reasons. Again, in most cases, the termination for those reasons is never explicit, whether it's race, sex, age, or sexual orientation. A lot of these cases, the argument would be it was subterfuge, and you're really getting rid of me for this reason, and then you're off to the races in terms of all the standards and tests that courts have already developed in other areas of the law. And one other thing that does come to mind as well in terms of the another theory goes back to what Justice Kennedy said in the Obergefell case, or reiterated in the Obergefell case, that marriage is a fundamental right. And so if somebody is either explicitly or using subterfuge terminated because they are married to a same-sex person of the same sex, is a court going to allow that because marriage is a fundamental right between two people, whether it's male and male, female, female, or heterosexual. So right now in Ohio, a person can get married. I can get married to a man over the weekend and be terminated from my job on Monday because I did that, because there's no non-discrimination provisions in the law. However, I do think this is where the court might carve out, or the inroads might be made into some of those exceptions. I'm going to talk about a little bit now about some of the benefits for same-sex partners. First of all, when it comes to giving benefits to same-sex partners, yes, you can ask for proof of marriage, but you can't just ask same-sex partners and not heterosexual partners. In other words, if you have a question or an issue, or if it's your common practice, no problem, ask away. But don't just single out one group as opposed to the other. With respect to health insurance, there is a theory that private employers who are self-funded for purposes of health insurance may be able to discriminate and deny benefits to same-sex married couples in Ohio, even though they're married legally since Obergefell. And the theory is, and I'm not advising that private employers follow this, but the theory is that that's discrimination based on sexual orientation, and there's no law prohibiting discrimination based on sexual orientation. I think public employers, for some of the reasons I've mentioned, some of the constitutional reasons, and are much less likely to be able to get away with that. And again, I'm not advocating that anyone try that. A question came up this morning when I was doing this presentation about whether or not the IRS has yet issued guidance on whether the Obergefell decision means that there was a qualifying event for somebody to get on health insurance. What I mean by that is that if somebody gets married today in the middle of a health insurance year, not open enrollment, that's a qualifying event, and they can get on and your employee can add their spouse to their health insurance. Well, there were a lot of people who were lawfully married in other states on the date the Obergefell decision was issued, which meant they automatically became lawfully married in Ohio as of that date. The question then is whether or not that is a qualifying event for purposes of adding them to the health insurance. I think it probably is, even though I'm not aware of the IRS having made that ruling, and I think you should treat it that way if requested by your employees. Another related issue to health insurance that you're going to likely see is now in Ohio, up to the point where Obergefell was issued, prior to that point, I should say, if a same-sex couple was married, let's say in Massachusetts 4 years ago, and they adopted children, in Ohio, only one parent is recognized as the adoptive parent up until Obergefell. Now, same-sex couples have the same rights, and they both can be the adoptive parent. So if that happens, you might have another qualifying event. In other words, if the married couple, the spouse of that person, they've been married for a while, they decide now we're going to be both the adoptive parents, that now puts as a qualifying event that would allow them to put their children on the employer's health plan as well. What I don't know, and I just thought about this as I was doing the presentation this morning, is whether or not that's a qualifying event as well for FMLA purposes. So I've been, in fact, acting as this person's parent, this kid's parent, but now I'm formally adopting him or her. Do I get 12 weeks off under the FMLA? I think the answer is probably no, but it could be an issue that comes up. Bereavement leave, FMLA, those kind of things are pretty obvious. A spouse is a spouse now, and it really doesn't matter. I mean, it really shouldn't be rocket science in terms of figuring this out. Of course, for purposes of the FMLA, the U.S. Department of Labor, since Windsor, was already considering looking at that based on the place of celebration. So if they were married, if you have employees who are married in different states that recognize same-sex marriage before Obergefell, it's still going to be, it's going to be no different. You've been following those rules. One thing I guess I should say, and I did this morning too, I might, depending how things go, be a couple minutes over, so I hope you can stick around a couple minutes past 2. One thing I wanted to mention to you, and this is as good a place as any, is a House bill, Ohio House Bill number 296. So House Bill 296 was introduced in the Ohio House on August 5th, 2015. It is a bill that is designed to permit discrimination, to permit businesses to discriminate with regard to same-sex marriage ceremonies. And what the law says, and you can look it up, it's pretty darn short, not even 2 full pages. Actually, the substance is basically 1 page. First of all, it says a business means a sole proprietorship, partnership, corporation, or any other business entity, et cetera, et cetera, et cetera. A ceremony is defined as any activities relating to participation in creating a marriage union between 2 persons of the same sex. And then it goes on to say, no business shall be required to participate in a ceremony creating a marriage union between 2 persons of the same sex if participation in the ceremony violates the business's right of conscience or freedom of religion. First of all, I'm not sure how a corporation has a right of conscience or freedom of religion. I know we have the Hobby Lobby case, but that was under the ACA. Obviously, that would be part of the argument for somebody who, if this becomes law. I also would question, and I have no indication it's going to become law. I know nothing about its chances one way or the other. If I had to guess, I'd say it's not going to go very far. I think one could argue that making a cake for a same-sex wedding or any wedding is not participating in the ceremony, as opposed to a justice of the peace or a judge or a priest or rabbi or minister. And make no mistake about it, priests or rabbis or ministers don't have to participate in same-sex weddings if they don't want to, and it would not be considered discrimination under the current status of the law. We'll have to just keep our eye on where that's going to go, if any place. I want to make a comment now, or a couple thoughts. You folks may have already thought about this, but a lot of employers have domestic partner benefits. Especially prior to Obergefell, a lot of employers did that because Ohio doesn't recognize same-sex marriage. So if 2 people have been living together as if married, but were not allowed to get married in Ohio, then the domestic partner benefits, whether it's health insurance or sick leave or a whole host of other things, bereavement leave, could all apply. I think the underlying reasoning for the domestic partnership rules or policies has now gone away with Obergefell. I'm not saying you can't keep them, but I think you should think about whether you want to keep them if you have them, because now same-sex couples can marry and get the same benefits as opposite-sex couples. Maybe something that a lot of employers decide to get rid of or modify. All right, let's talk a little bit about state and local protections. There aren't a whole lot, so there won't be, well, there's some local protections, but as I mentioned before, there isn't any specific statute in Ohio, although there are in many states. The one thing I do want to point out to you is that historically, Ohio's non-discrimination statute, 4112 of the Chapter 4112 of the Revised Code, has been interpreted consistent with Title VII, so that courts in Ohio will look at what a federal court did on a Title VII case, let's say on race discrimination, and oftentimes apply the same legal standard. There's nothing in the law that says they have to do that, but if federal courts, and I think that's more likely where we'll see more changes before state courts, but if federal courts start applying Title VII to sexual orientation, will Ohio automatically do that in their courts, or will they say this is where we've got to go our own way? Again, time will tell. I don't know what the answer to that question is. The another thing I want to point out to you is, and this applies only to at-will employees. So I said earlier that if I get married to to a man over the weekend, I can get fired from my job on Monday. That's a true statement. But if I'm an at-will employee, I may have a cause of action under this tort theory of a violation of public policy. So since this Painter case in 1994, Ohio courts have held that it is unlawful for an employer, and we're talking about private employers primarily or unclassified public employees. It's unlawful to terminate somebody in violation of public policy. So, for example, there was a case where an employer didn't want to have to deduct child support from the employee's paycheck. The employer was taken to court, said, okay, I'll deduct it because I have to. They did it, and then they fired the employee. The employee's termination was found to violate public policy in favor of child support payments and facilitating those payments. That was a public policy determined by the court to exist in Ohio law. Well, if marriage is a fundamental right, is it not a public, will a court say that terminating somebody for marrying someone of the same sex is a violation of public policy? That very well could happen. I'm not going to spend a lot of time on this, but basically there's four elements that a court will look at in these kind of cases. First of all, is there a clear public policy manifested in state or federal constitution, statute, or administrative regulation, or in the common law? That's the clarity element. If a person's dismissed under circumstances like the facts of a particular case, would that jeopardize the public policy? That's the jeopardy element. Was the plaintiff's dismissal motivated by the conduct related to the public policy? And finally, did the employer have an overriding justification unrelated to that public policy? So that's an issue that I think is going to get some more attention in Ohio courts under these circumstances. Right now, you have in front of you a slide that addresses or tells us the places in Ohio that have workplace protections for sexual orientation. As you can see, most of these are cities. There's a couple counties on there. One of the questions, I'm not aware of any legal challenges to any of these local ordinances. I'm certainly aware that Columbus and I believe Cincinnati and maybe some others have had these in place for a long time, and other municipalities are looking at this. The whole question here is, under home rule authority, does a city have the right to promulgate one of these, such a policy, such an ordinance, even though state law doesn't include that protection? And time will tell, and maybe it'll be unnecessary if the state passes a law down the road, or if Title VII is viewed to protect employees in these situations. I want to talk a couple minutes about religious stuff. I'm going to talk about some things going on that have already taken place both before and since Obergefell. So, as I mentioned earlier, many states, and I should have the number, and I apologize, I don't, but many states in the country have a law that bans discrimination based on sexual orientation. In several of these states, individuals or organizations have raised the issue of whether or not my religious objections, assuming they're sincerely held, whether my right to exercise my religion is violated if I have to employ or provide services to a same-sex couple. Or a same-sex, whether it's a marriage or just an individual, based on their sexual orientation. And in every case that I've come across, and there's only been about 5 or 6, and there may be more, the sexual orientation prohibition has prevailed in court over someone's religious objections. So, for example, there was a case, I believe it was out of Maine, where somebody had a bed and breakfast or an inn, and they didn't want to provide wedding services to a same-sex couple, even though they did it for heterosexual couples. And they said that they had a sincerely held religious belief against same-sex marriage. Court said that religious belief is not trumped by the statute. And if you want to do it for some people, you got to do it for everybody under these circumstances. And I think those kind of things are going to be more, or that decisions are going to even come down more like that as these cases wind their way through courts because of the Obergefell decision. And I know I keep going back to it, but the fundamental right to marry. In fact, there was even a case out of Illinois involving a Catholic organization doing adoptions, and they raised the issue we shouldn't have to offer adoptions to same-sex married couples, and the court said, yeah, you have to, and they got out of the adoption business. So I think courts are pretty serious about, well, I shouldn't say serious. I think courts are pretty clear so far about who's going to prevail over what. And that's going to be a challenge for you in your workplace as well. So what happens if you're a social services agency and an allegation or some situation arises where one of your employees has to provide services to a same-sex married couple, or refuses to do something based on someone's sexual orientation because I have a religious objection. I think, and we're going to have to wait and see what the courts do, but I think courts are likely to say you can hold that religious belief, but you can't use it to discriminate in the workplace. You can't use it to avoid having to do an aspect of your job. Again, we're going to have to wait and see. Note that in Ohio, there is no Religious Freedom Restoration Act, which is used to justify discrimination based on sexual orientation if somebody has a religious objection. Now, having said all that, we also have to recognize that in the Hobby Lobby case, the U.S. Supreme Court allowed Hobby Lobby not to offer certain contraceptives because it violated their religious beliefs under the Affordable Care Act. Again, it's a little bit different standard or approach, but certainly anybody who is going to bring that case or pursue that case on behalf of religious objectors is going to cite to the Hobby Lobby decision. There is proposed federal legislation in the U.S. House of Representatives. Was proposed on July 23, 2015, to amend the list of protected classes to include sexual orientation. The way things work in Washington, it's really hard for me to imagine that's going anyplace, especially as we are just shortly over a year from the election, even though it seems like it's tomorrow with how much news coverage there is for it. I want to talk about something. It's not in the slides, but it's something that I think is significant, especially for public employers, but I think across the board, to just illustrate how fast some of these things might move. So this is on August 7th, 2015, the Board of Professional Conduct of the Supreme Court of Ohio issued an opinion 2015-1 it's entitled Judicial Performance of Civil Marriages of Same-Sex Couples. Now, let me make this clear. This is not a decision of the Ohio Supreme Court. It's an advisory opinion that is binding on judges and magistrates. But I think you'll see maybe how it might be applicable to others as well. So in this decision, what happened was this board said we need some guidance for judges now that Obergefell was decided. And what they said is that, okay, when a judge performs a civil marriage ceremony, the board determined that the judge is performing a judicial duty, and therefore he or she is required to follow the code of judicial conduct and the performance of that duty? Well, every judge takes an oath to do, among other things, uphold the Constitution. And according to this board and case law, the oath is a reflection of what the board said is a self-evident principle that the personal, moral, and religious beliefs of a judicial officer should never factor into the performance of any judicial duty. A judge's oath to support the constitutions of the United States and the state of Ohio requires the judge to recognize and adhere to binding court interpretations of the same, like Obergefell. They didn't say like Obergefell, but we know that's what it is. Keep in mind, a judge is not the only public official that takes an oath. So some of these theories could apply to other public officials when it deals with upholding the Constitution. The board noted that in 2001, there was a Cuyahoga County, it might have been I don't know if it was a common police court or municipal court judge, was actually suspended for 6 months after she denied a pregnant defendant's post-conviction motion for probation and continued her prison sentence in order to prevent her, the defendant, from having an abortion. The Ohio Supreme Court reasoned that the judge had revealed a bias toward the defendant based on conduct that she thought was morally inappropriate, and that's a violation of the oath. Again, I'm not trying to equate abortion with same-sex marriage, but that's the example this board used. So the board went on to say that a judge should further be mindful of the requirement under, and it cites a rule, to perform administrative duties without bias or prejudice, despite the judge's personal, moral, and religious beliefs. A judge may not allow sexual orientation to affect employment decisions or the judge's treatment of court personnel, court officials, attorneys, and jurors, despite the judge's personal beliefs about sexual orientation. And what the board said is that one thing, first of all, not surprisingly, and actually I just got a question and I think I'm going to answer this question. The question is, if a judge does not perform marriage ceremonies presently, that judge does not have to perform same-sex marriage ceremonies because she does not perform that presently. Is this a correct assumption? And the answer, of course, is maybe. So here is the answer. The answer is that if a judge has been performing ceremonies and wants to continue, the judge can't only do it for heterosexual couples. That's obvious. But the board went on to say that if after Obergefell, a judge says, I'm not doing any because I don't want to marry gay people, that could also be a violation of the judge's oath of office. So if the judge never did it and still is not going to do it after Obergefell, that's fine. And what the board noted in here, and you can read this online, the Supreme Court website, but what the board noted, the Ohio Supreme Court website, what the board noted in there was that sometimes where the judge is located might matter, because if there's only one judge in a small county and that judge says, I don't want to do anything because I don't want to have to marry gay people, then that might be more of an issue than if a judge says, I'm not going to do any in Franklin County. That was an implication. They didn't come out and say that, but that's just one of my thoughts or conclusions from this. So again, it applies only to judges. I think we can see how it could apply to others. And that was fast after Obergefell. So we're going to have to wait and see what happens. I appreciate your time and that the most of you who stuck with me all the way through. As I said before, the PowerPoint is going to be available for your download or printing on our website, fishelhast.com. I am going to stick around for a couple minutes, and in case anybody has any questions, or certainly you have my email if you want to follow up with questions later on. So I really appreciate it, and we would really appreciate any feedback that you guys have in terms of this presentation in particular, or other topics you might want to have folks cover. I guess I'll put in a commercial for the Ohio Public Employer Labor Relations Association. Um, they have their annual conference in February. I know many of you attend. I just got asked today to present on this similar topic on one of the days of the conference, and maybe we'll know more then too. So I don't think the presentation will be redundant. Plus, there's a lot of good information at that conference. I would highly encourage the public employers to attend. So thank you. Like I said, I'll stick around and hear if there's any questions or see if there's any questions.